Do you know, even your bedroom, the area sub-chief knows how you sleep. Macho ya serikali iko kila mahali. The government's eyes. We have the DCI, we have the police, we have the NIS, we have the military, we have uniformed police officers, not uniformed police officers. Those are the eyes of government. We have the provincial administration, the local assistant chief, the village elders, the chiefs, the DCs. All these people are government. Don't they have the right to know what you are thinking, to know what you are posting? The government cannot interfere with the freedom of communication. The government cannot take the country into the dark ages where communication could not be there. Welcome to Court Helicopter. It is always a pleasure to bring these explainers to you and explain to you the law, why the courts are doing what they are doing, why the law is the way it is. We know sometimes we rattle the snake. The late Michuki said, if you rattle a snake, it will bite you. We know our episodes are rattling people who have myths, stories that are not true. This is an explainer that deals with the modern tool, the website. Do you know there is no business now that does not have a website? Do you know there is no government agency that doesn't have a website? A website, for example, you check our stories on Court Helicopter platforms, the YouTube, the Instagram, the Twitter, you'll get TikTok, but more important, you'll get our website. Our stories don't miss on the website. If you're a good reader and a slow listener, you always get our stories on our website. The question is, how fast has a website become a very integral tool in the running of business? This is because of the digital era. Websites are digital. Business has gone digital. And that is why Court Helicopter has also its own website. The government realized that websites can also be used as a way to abuse people, as a way to extort people, as a way to post certain stories that can make people commit suicide. And they created the law and created an entity that can shut down a website without notice to the owner of the website. Once this law was amended, people rushed to court, to the Constitutional Court, and challenged those provisions. This was in the case of Milimani High Court, case number HCC HRPET stroke E671 stroke 2025. That is petition number E671 of 2025. This is by the Law Society of Kenya. I'm a member of the Law Society of Kenya. The Law Society of Kenya went to court under Section 4 of the Law Society of Kenya, where Law Society of Kenya is mandated by statute, by the law, to defend the law and represent the public interest. The Law Society of Kenya sued the Attorney General and the Communication Authority of Kenya and two others. This was a judgment before Justice Honorable Lady Justice Nyaundi Patricia Mande. The question was, can you close, can a committee have power to close websites without the involvement of judiciary? That was the question before the court. Can that happen? The judge looked at this in paragraph that is in page 14 and asked whether the impugned provisions of the amended act violate the Constitution. The judge looked and provided that the provisions that were amended gave the committee the power to determine that a website or an application is offensive and then proceed to issue a directive to render that website or an application inaccessible. The website is also inclusive of apps. Everybody has an app today. Everybody has a website. In effect, the committee is given extensive powers to limit Article 32, 33, 34 of the Constitution, absent of judicial supervision. What did the judge find? The judge said, because of the legislature, Parliament's failure to comply with the mandatory constitutional parameters governing the limitation of rights, I have no hesitation in declaring Section 61JA of the Computer Misuse and Cybercrime Amendment Act unconstitutional. The impugned provisions restricts the freedoms guaranteed under Article 32, 33, 34. So the judge is giving reasons. Why did she declare that section unconstitutional? One, because it restricts the freedoms guaranteed under Article 32, 33, and 34. Two, it falls outside the strict confines of Article 24, which demands that any limitation must be clear, precise, reasonable, and democratically justifiable in an open and democratic society. The state tried to prove, the judge said the state has not discharged its burden to show that the limitation is both necessary and at least restrictive means available. That is why the judge declared that section unconstitutional. Number two, the judge went further to give further reasons that the amendment confers upon an administrative body. That committee is an administrative body, sweeping authority to impose prior restraint, the most severe form of censorship in the absence of procedural safeguards and evidentiary threshold. So that committee was given power by the Computer Misuse Act without involvement of the judiciary. What was the effect of this committee's powers? The provision invites arbitrary enforcement and produces a chilling effect on a legitimate expression, compelling individuals and digital platforms to self-censor out of fear of sanction. So the court is saying, if this committee is allowed to continue, it will stifle the democratic right of expression. Any application, any website, the owners must be asking, is the DCI going to come for us? Is the DCI Subarus around here? That is not what the Constitution envisaged. What will happen? Everybody will keep quiet. Digital platforms, websites will keep quiet. Apps will keep quiet. Then such anticipatory silence is antithetical to the constitutional commitment to a vibrant and uninhibited marketplace of ideas under Article 32, 33, 34, where the Kenyan said everybody has a right to express themselves, the right to your opinion. He goes on to say, and the question is, but the state has powers to have intelligence. Do you know, even your bedroom, the area sub-chief knows how you sleep. Macho ya serikali iko kila mahali. The government's eyes. We have the DCI, we have the police, we have the NIS, we have the military, we have uniformed police officers, not uniformed police officers. Those are the eyes of government. We have the provincial administration, the local assistant chief, the village elders, the chiefs, the DCs. All these people are government. Don't they have the right to know what you are thinking, to know what you are posting? The judge said, what also emerges from the review decision is that even if the surveillance powers of the state are constitutionally permissible, yes, that power is allowed. Such powers should be exercised within clearly defined and narrowly tailored boundaries surrounded by robust safeguards. These principles are found in Article 24. The judge moved ahead and said he declared that section unconstitutional. Another section that the judge declared unconstitutional is section 27, which says, what is the amendment? A person who individually or will others persons willfully communicate either directly or indirectly with another person or anyone known to that person commits an offense if they know or ought to know that their conduct B, detrimentally affects that person or is likely to cause that other person to commit suicide. So the law is saying, if you can communicate in a manner and that person commits suicide. For example, we post our website on Court Helicopter story. Then Bramwell commits suicide. Or Cyrus commits suicide. Then that website must be brought down. The question the judge is asking, how do you know that Bramwell is going to commit suicide? How do you decide that this message is likely to cause somebody to commit suicide? What did the judge say? The impugned provisions fall into the same constitutional infirmity. Section 27(1)(b) now criminalizes communication that is likely to cause the person to commit suicide, thereby introducing a speculative, indeterminate, and wholly subjective basis for criminal liability. It is speculative. How do you know that Bramwell is going to commit suicide? You can't. People who commit suicide are patients. People who commit suicide have tendencies to commit suicide. The judge looked at that and declared that provision unconstitutional. What did the judge say? For the foregoing reasons, the consolidated petitions partially succeed with the following orders. Section 6(1) (JA) and Section 27(1)(b) of the Computer Misuse and Cybercrimes Amendment Act 2025 are declared unconstitutional. Signed and dated virtually at Nairobi this 2nd day of July 2026 by Honorable Lady Justice Nyaundi Patricia Mande. What are the lessons here? That the government cannot interfere with the freedom of communication. The government cannot take the country into the dark ages where communication could not be there. The freedom of Court Helicopter is now guaranteed. We cannot censor our low topics. We cannot be gagged. That is why we are exercising the freedom. This judge has ensured everybody has a right to think, everybody has a right to post in their website, and everybody has a right to post their stories on their apps. This is the biggest win for the democratic space of expression in this country. Wakili Dan Sanumari, always a pleasure.